that particular counsel kind of ganged up on him and almost defended the infidelity by Ms. Vulpetti.
Vulpetti versus Vulpetti. Both parties are present in the virtual courtroom along with their respective attorneys. Mr. Sherlin on behalf of the plaintiff, Mr. Vulpetti, Ms. Wagener on behalf of the defendant, Ms. Vulpetti. We are here on the defendant's motion to enforce the judgment of divorce and to send the children to counseling. Ms. Wagener, I have read both the motion and the response, by the way.
Thank you, Your Honor. I'll just respond to Mr. Sherlin's response rather than reiterate my motion. But I think ultimately the purpose of our motion was to get the children into counseling. There are some significant concerns from Ms. Vulpetti. She does indicate that, and I've listened to, she has a recording of Mr. Vulpetti calling her a whore. So his denial of that is a flat out lie because it's on an actual recording. She has text messages where he's stating that he booked their son for a counseling appointment, and her response is that it would have been nice if you would have consulted with me. Like, she had no say in the process. She didn't object to the counseling, but she didn't have any, it was not a joint decision. And there's text messages to validate that. Her youngest most recently just told grandma that daddy has a secret about mommy and that she's done something bad. This is a regular reoccurrence with the children, is this theme that mommy has done something bad. And she even has a text message from May 17 where he says, "Will you lie to them when they ask about your infidelity? Good thing I saved all the messages to show them when they are old enough." And so while it's clear he doesn't necessarily intend to tell them until they're older, the mere fact that he's indicating there's something to tell them is so unbelievably inappropriate. So because of all of this, we really feel the children, both of them, need to be in counseling. She did look at the proposal from Mr. Sherlin's office, and she was in support of the office and would prefer to use Taylor Broadbeck from that office after having reviewed all of the bios that are listed on the website. So ultimately, I would just ask that the court enter an order for the children to engage in counseling and for that to be with Mr. Broadbeck, if that's acceptable to Mr. Sherlin. Just gently remind Mr. Vulpetti that it's really inappropriate to be talking to the children about anything as it relates to the divorce other than just mom and dad are no longer together and it didn't work out.
Mr. Sherlin.
Thank you, Your Honor. I think that we agree that the communication to the children is when they ask, and my client reports that they do, that mom and dad aren't together and both parents love you. Look, the facts of this case are, the history of this case factually is that Ms. Vulpetti did end the marriage because of her infidelity, but it's not that the children need to participate in that or know that, but they ask questions about why aren't mom and dad still together. My client tries to answer them in an age-appropriate manner that says, well, mom and dad didn't get along, or, mom and dad needed to live separately. That type of generic response to the children of this age. My client is very concerned that the therapy is just a fishing expedition to try to make some sort of, case against my client. And it's really strange that the defendant actually asked to use a therapist who was the couples counselor for the parties prior to the divorce being filed. And the only reason my client can think of that would be the request of the court is because that particular counselor, from my client's perspective, kind of ganged up on him and almost defended the infidelity by Ms. Vulpetti. So my client strongly disagrees with the court that, or with the defendant, that he's in any way involving the children in the facts or the history of the case or the actions of Ms. Vulpetti. But admittedly, Your Honor, my client was really hurt by the actions of Ms. Vulpetti. There's no doubt about it. But he's been working on that and he's processing that. And I think he's getting to the point where, and he is to the point, he tells me, where he's accepted the history of the case, and it's really just a matter of parenting. He tells a very different story about the counselor that the parties tried for their son. He found the counselor, arranged the counselor, and thought he had the agreement of Ms. Vulpetti. Apparently now she's saying she didn't agree, but she didn't object. I don't know what that means. But their son did see that counselor, and that counselor reported that it didn't seem like there was anything that really needed to be worked on. My client tried another appointment, and the party's son became very upset about the idea of going to another appointment. And that's where it was left. My client did the right thing when he was hit with this motion, as opposed to, say, a request or communication about, can we talk about counseling? When he was hit with this motion, he contacted the children's teachers and said, hey, how are the children doing? And forwarded the emails to me. And both teachers give glowing accounts of how well the children are doing. And certainly, the court's done this long enough. We've all done this long enough that we know if these children are struggling, it shows up at school. And there was no equivocation at all by the teachers that they're great kids and they're doing very, very well. So I did not offer counseling in the motion response. What I offered is if the court believes that counseling needs to be pursued, that I had on a prior case very good experience with Martinos as a husband and wife counseling team. It's interesting now, though, that Ms. Vulpetti says, well, even if we do counseling, I don't want to use those people. And I think, honestly, it's because her angle on this is to weaponize the counselor as opposed to a true therapeutic approach. A true therapeutic approach would keep the children's information confidential, and it wouldn't be seeking information or an alliance with a therapist to promote future litigation. Well, my client feels like he has done the due diligence here and has checked with the obvious sources that would tell him whether the children were suffering or dealing with any issues that needed to be addressed in counseling, and he didn't find it. So I would ask the court to deny the motion regarding counseling. In the alternative, if the court decides counseling is appropriate, I think the Martinos would be, I'm only going by experience, and they were not therapists that I suggested in the case. It actually came from opposing counsel, and I was very impressed how they handled that particular very high conflict case. So the requested relief is to deny the motion. My client feels that the motion was unnecessary, that it could have been done through discussion between the parties. And, he's trying to fix his transmission on his vehicle right now. And these attorney fees are preventing that from happening, and would ask the court to consider whether this motion was well grounded in fact and whether the court would grant attorney fees to him.
All right, thank you. Well, this court believes that counseling is important for children who are experiencing divorce, both while it's pending and potentially afterwards as well. And so the court is going to order counseling for these children. I will indicate that the children should go see the Martinos. I'm also going to order that both parties, if they're not already involved in their own individual counseling, that they need to do that. The temperature in this case needs to be brought down to a manageable level. It's clear to me that there's still a lot of conflict, a lot of hurt feelings, all of that, and both parties need to work through that in the best interest of their children. Children pick that stuff up regardless of what is said or not said to them. And today I'm not going to get into all of that. Just that these parties pick up on the tension between their parents and they internalize it and they blame themselves. So I do want them to go to counseling. As I said, it'll be the Martinos, and I really believe that both parties need to also go to individual counseling to help them work through their own issues so that they don't spill over to these kids. All right, and I am going to deny the request for attorney fees. Your Honor,
Will we, the out-of-pocket cost, I don't know if insurance will apply or not, but will the out-of-pocket cost be shared between the parties?
The uninsured medical expenses part. My understanding is that most insurance companies will not pay for court-ordered insurance, so how the parties approach that is up to them.
So right now, Your Honor, the parties divide child-related expenses equally as a
All right.
deviation. And then will the Martinos, the counselors, set the horizon on this? In other words,
Yes, I always put the power or the authority, the control in the hands of the counselors as to how things should progress, how
Okay.
many visits, what it should look like, all of that. That's their lane. And I would expect that the children's counseling is kept confidential.
Okay, so the children's counseling is confidential, so we can't attach that counseling information to motions, for instance.
No.
Okay, perfect.
All right. We're adjourned. Thank you.
Thank you, Your Honor.